everyone, welcome to ClearIAS. In today's video, we will be discussing about quasi-judicial bodies in India. I am Ujjwala Pullala, an educator at ClearIAS. Introduction. So firstly, what are quasi-judicial bodies? Quasi-judicial bodies are not courts but have the power to interpret the laws. See, as from the name itself, we can understand that they are not fully judicial bodies. They are quasi, that is, they are partial or similar to the judicial bodies. So they are not courts, but they have the power to interpret various laws in the country. They are formed with the objective of reducing the burden on the judicial bodies. They are concerned with the administrative bodies. Their judgments can be challenged in the court of law. Their powers are generally limited to any particular agency or area of specialization. So as we'll see further, that is for different areas like human rights, intellectual property rights, and to deal with the grievances of the consumers, we have different specialized bodies. The decisions of these bodies are dependent upon the existing laws. That is, these bodies they do not make any new laws. However, the decisions will be dependent on the already existing laws of the land. They have the power to impose penalties on the party if found guilty. First one is National Human Rights Commission (NHRC). NHRC is a statutory body, that is, it is made through a law of the Parliament. It was established through the Protection of Human Rights Act of 1993. It is considered as the watchdog of human rights in the country. Composition. The commission consists of a chairman and 4 other members. The chairman should be a retired Chief Justice of India. The other members should be serving or retired judges of Supreme Court, a serving or retired Chief Justice of a High Court, and 2 persons with special knowledge or practical experience related to human rights. The Commission has the following ex officio members, that is, these members are considered as the part of the NHRC based on the position they hold. They are the Chairman of the National Commission for Minorities, the Chairman of the National Commission for SCs, the Chairman of the National Commission for STs, the Chairman of the National Commission for Women, and the Chairman of the National Commission for Backward Classes, the Chairman of the National Commission for Protection of Child Rights, and the Chief Commissioner for Persons with Disabilities. Appointment. The chairman and members are appointed by the President on the recommendations of a 6-member committee consisting of Prime Minister, Speaker of the Lok Sabha, Deputy Chairman of Rajya Sabha, leaders of the opposition in both the houses of Parliament, and Central Home Minister. Term of office. The chairman and the members hold the office for a term of 5 years or until they attain the age of 70 years, whichever is earlier. After the completion of the tenure, they are not eligible for further employment in central or state government. Removal from service. The chairman or the members can be removed by the President under the following circumstances: if he is adjudged and insolvent, if he engages in any other paid employment, if he becomes unfit by reason of infirmity of body or mind, if a competent court declares him to be of unsound mind, if he is sentenced to imprisonment for an offence. Other than the above reasons, the President can remove them on the grounds of proved misbehavior or incapacity. Functions. To inquire into any violation of human rights or negligence in the prevention of such violence by a public servant. To visit jails and detention places. To review the various safeguards provided for the protection of human rights. To intervene in any proceedings before the court. To study the various international treaties and instruments. To promote research in the field of human rights. To promote literacy about human rights among the people. To encourage the efforts of NGOs working in the field of human rights. State Human Rights Commission (SHRC). The Protection of Human Rights Act of 1993 provides for the creation of a State Human Rights Commission in every state. With respect to the subjects mentioned in state list and concurrent list, SHRC has the authority to inquire into violations of human rights. Composition. SHRC consists of a chairperson and 2 other members. The chairperson of SHRC should be a retired Chief Justice of a High Court, whereas in the case of NHRC, he should be a retired Chief Justice of India. The members should be serving or retired judge of a High Court or a district court having a minimum experience of 7 years and a person with knowledge or practical experience in the field of human rights. Appointment. The chairperson and the members are appointed by the governor. The appointment is based on the recommendations of the committee consisting of the following members: Chief Minister as its head, Speaker of Legislative Assembly, State Home Minister, Leader of Opposition in the Assembly. In the case of bicameral legislature, the Chairman of Legislative Council and the Leader of Opposition in the Council will also be the members of the committee. Term of office. The chairperson and the members hold office for a period of 5 years or until they attain the age of 70 years, whichever is earlier. The chairperson and the members are not eligible for further employment under a state or central government. Removal from service. The chairman or the members can be removed by the president under the following circumstances. So as we can understand here that though governor is the one who appoints the chairman and the members, it is the president who is responsible for their removal from service. If he is adjudged and insolvent, if he engages in any other paid employment, if he becomes unfit by reason of infirmity of body or mind, if a competent court declares him to be of unsound mind, if he is sentenced to imprisonment for an offence. Other than the above reasons, the President can remove them on the grounds of proved misbehavior or incapacity. Functions. To inquire into any violation of human rights or negligence in the prevention of such violence by a public servant. To visit jails and detention places. To review the various safeguards provided for the protection of human rights. To intervene in any proceedings before the court. To study the various international treaties and instruments. To promote research in the field of human rights. To promote literacy about human rights among the people. To encourage the efforts of NGOs. Central Information Commission (CIC). The Central Information Commission was constituted through an official Gazette notification under the Right to Information Act of 2005. The complaints and appeals related to the offices, financial institutions, PSUs, etc. under the central government and union territories are looked after by the CIC. Composition. It consists of a Chief Information Commissioner and not more than 10 Information Commissioners. They are appointed by the President based on the recommendations of a committee consisting of Prime Minister as chairperson, Leader of Opposition in the Lok Sabha, and Union Cabinet Minister nominated by PM. Tenure of Service. They hold office for a term of 5 years or until they attain the age of 65 years, whichever is earlier. The Chief Information Commissioner is not eligible for reappointment. However, the Information Commissioner is eligible to be appointed as CIC with his term not exceeding 5 years, including the tenure as Information Commissioner. That is, suppose if a person has worked as an Information Commissioner for a term of 3 years, then he can be appointed as CIC for the remaining tenure of 2 years. Removal from service. The CIC and other ICs can be removed by the President under the following circumstances. If he is adjudged and insolvent, if he gets convicted of an offence involving moral turpitude, if he engages in any other paid employment, if he gets unfit due to infirmity of mind or body, if he acquires any financial and other interest prejudicing his official functions. The President can also remove them on the grounds of proved misbehavior or incapacity. Power and functions. The Commission inquires the complaints from a person who couldn't submit an information request due to non-appointment of public information officer, who has been refused the requested information, who has not received response to his request, who thinks the charged fees to be unreasonable, who thinks the information to be incomplete, misleading or false. Any other matter regarding the information. The Commission has the suo motu power of inquiry. It has the powers of a civil court. The Commission submits an annual report to the central government which places it before each house of the Parliament. State Information Commission. The Right to Information Act of 2005 provides for the creation of a State Information Commission. The complaints and appeals related to the offices, financial institutions, PSUs, etc. under the state government are looked after by the State Information Commission. Composition. The Commission consists of a State Chief Information Commissioner and not more than 10 State Information Commissioners. They are appointed by the Governor based on the recommendations of a committee consisting of the following members: Chief Minister as the chairperson, Leader of Opposition in the State Legislative Assembly, and a State Cabinet Minister appointed by CM. Tenure of Service. They hold office for a term of 5 years or until they attain the age of 65 years, whichever is earlier. The State Chief Information Commissioner is not eligible for reappointment. However, the State Information Commissioner is eligible to be appointed as CIC with his term not exceeding 5 years, including the tenure as the Information Commissioner. Removal from service. The state CIC and other state ICs can be removed by the Governor under the following circumstances. So that is, in the case of state CIC and Information Commissioners, it is the Governor who is responsible for both the appointment as well as their removal. If he is adjudged and insolvent, if he gets convicted of an offence involving moral turpitude, if he engages in any other paid employment, if he gets unfit due to infirmity of mind or body, if he acquires any financial and other interest prejudicing his official functions, the Governor can also remove them on the grounds of proved misbehavior or incapacity. Powers and functions. The Commission inquires the complaints from a person who couldn't submit an information request due to non-appointment of public information officer, who has been refused the requested information, who has not received response to his request, who thinks the charged fees to be unreasonable, who thinks the information to be incomplete, misleading or false. Any other matter regarding the information. The Commission has the suo motu power of inquiry. It has the powers of a civil court. The Commission submits an annual report to the state government which places it before the state legislature. Competition Commission of India (CCI). CCI was formed on 14 October 2003 for enforcing the provisions of the Competition Act of 2002. Hence, it is a statutory body. Its headquarters is in New Delhi. It consists of a chairperson and 6 other members appointed by the central government. Objectives. For creating fair and healthy competition in the economic activities. To protect the interests of the consumers and work for their welfare. To eliminate practices having adverse effect on the competition in the markets. To create public awareness and provide training on the issues related to the competition. National Consumer Disputes Redressal Commission (NCDRC). It was formed in 1988 under the Consumer Protection Act of 1986, so it is a statutory body. NSDRC is headed by a sitting or retired judge of Supreme Court. Its headquarters is in New Delhi. Objectives. To provide speedy and inexpensive resolution of consumer disputes. To entertain a complaint the value of which is more than 1 crore. to exercise appellate jurisdiction over the orders of the state and district commissions. Intellectual Property Appellate Board. So firstly, intellectual property rights are the rights granted over the creation of minds, and the appellate board here, it deals with the grievances concerning the granting of such rights. It was established by a Gazette notification on 15 September of 2003. It has its headquarters in Chennai. The appeals against the decisions of the registrar under the Trademarks Act of 1999 and the Geographical Indication of Goods Registration and Protection Act of 1999 are heard by IPAB. Recently, an ordinance was signed, that is, Tribunal Reform, Rationalization and Conditions of Service Ordinance of 2021, shutting down IPAB. Income Tax Appellate Tribunal. ITAT was set up on 25th January of 1941. It deals with the appeals under the Direct Taxes Act. It is the oldest tribunal in the country and is thus referred to as the Mother Tribunal. It provides an inexpensive and easily accessible justice to the litigants. The motto of ITAT is Nishpaksh Sulabh Satvar Nyay, that is, Nishpaksh means unbiased or impartial, Sulabh, which means easy, Satvar is quick, and Nyay is justice. The members possess legal and accountancy expertise necessary for the scrutiny of relevant financial documents. Railway Claims Tribunal. The Railway Claims Tribunal Act was enacted in 1987 for the disposal of various claims against the railways. The principal bench of the tribunal is at New Delhi. The rules governing RCT are the Railway Claims Tribunal Procedure Rules of 1989, the Railway Accidents and Untoward Incidents Compensation Rules of 1990. Term and composition. The tribunal consists of a chairman, 4 vice chairmen, such number of judicial and technical members as the central government deems fit. The chairman holds office for a term of 5 years or the age of 65, whichever is earlier. The vice chairman and other members hold office for a term of 5 years or the age of 62 years, whichever is earlier. Aims and objectives. To determine the compensation for loss, destruction, damage, deterioration or non-delivery of goods or animals. To provide compensation for death or injury to passengers caused due to railway accidents. To reduce the burden on the courts and for quick disposal of claims. Customs, Excise and Service Tax Appellate Tribunal, CESTAT. It was initially constituted as Customs, Excise and Gold Control Appellate Tribunal by the Customs Act of 1962. It was changed to its present form of Customs, Excise and Service Tax Appellate Tribunal from 2003 with the inclusion of service taxes under its jurisdiction. It also exercises jurisdiction in anti-dumping matters. The tribunal consists of a president, vice president and other technical and judicial members. Appellate Tribunal for Electricity, that is APTEL. It was formed in the year 2005. The appeals against the orders passed by the central or state electricity regulatory commissions under the Electricity Act of 2003 are heard by APTEL. It also has the power of superintendence over the regulators and can also issue orders, directions or instructions as it considers necessary. The principal bench of the tribunal is at Delhi. Composition. APTEL consists of a chairperson, 1 judicial member and other technical members. The chairperson is someone who has been a judge of Supreme Court or a Chief Justice of a High Court. The judicial member is someone who is qualified to be a judge of High Court or has previously been one. 2 technical members are experts in electricity sector and 1 is an expert in petroleum and natural gas sector. The combination of judicial and technical members provides both the legal as well as the industry expertise. Insurance Ombudsman. The Office of the Insurance Ombudsman was created by the central government to deal with the grievances of the insurance policyholders. An ombudsman is to be selected from the persons with experience in insurance industry, civil services and judicial services. Appointment. The appointment of the ombudsman is based on the recommendations of a select committee comprising of a chairman of Insurance Regulatory and Development Authority (IRDAI), chairman of Life Insurance Corporation, chairman of General Insurance Corporation, a representative from the central government. Functions. To consider the complaints or disputes referred to it by the IRDAI relating to the insurance matters. To act as a mediator in the cases having the written consent of both the parties. National Company Law Tribunal (NCLT). It was established under the Companies Act of 2013 based on the recommendations of V. Balakrishna Iradi Committee. It was constituted on June 1, 2016 to deal with the laws governing the insolvency and winding up of companies. NCLT acts as the adjudicating authority under the Insolvency and Bankruptcy Code of 2016. The principal bench of the tribunal is located at New Delhi. The appeals against the decisions of the tribunal are dealt by the National Company Law Appellate Tribunal (NCLAT). Composition and tenure. The tribunal consists of a president and such number of judicial and technical members as the central government may deem fit. The president is a person who is or has been a judge of a high court for 5 years. The president and the members hold the office for a term of 5 years and are also eligible for reappointment for another term. Selection. The President of the Tribunal is appointed after consultation with the Chief Justice of India. The members are appointed based on the recommendations of a select committee consisting of the following members: Chief Justice of India, a senior judge of the Supreme Court or a Chief Justice of High Court, Secretary in the Ministry of Corporate Affairs, and the Secretary in the Ministry of Law and Justice, Secretary in the Department of Financial Services. Reserve Bank of India (RBI). The Reserve Bank of India was established on 1st April 1935 through the Reserve Bank of India Act of 1934. It is India's central bank and is fully owned by the Government of India since its nationalization in 1949. The central office of RBI is located in Mumbai. Structure. The affairs of the RBI are governed by a central board of directors appointed by the Government of India. The board consists of Governor, not more than 4 deputy governors, 4 directors representing the regional boards, 10 other directors from various fields, and 2 government officials. Functions. It formulates and implements the monetary policy in the country. It also acts as the regulator of the financial system, manages the foreign exchange according to the Foreign Exchange Management Act of 1999. Besides the Government of India, RBI is the one authorized to issue banknotes in the country. It acts as a banker to the banks. It regulates and supervises the payment settlement systems. It performs a developmental role to achieve the national objectives. Securities and Exchange Board of India (SEBI). SEBI was established on 12 April 1992 through the Securities and Exchange Board of India Act of 1992. It is the regulator of the securities and commodities market in the country. SEBI has its headquarters in Mumbai. Structure. The affairs of SEBI are managed by a board consisting of a chairman nominated by the Government of India, 2 members from the Finance Ministry, 1 member from the RBI, 5 members nominated by the Government of India. Functions. to regulate the securities market and to protect the interests of investors in the securities, to approve the laws relating to the securities exchanges, to list and delist any company from the stock exchanges, to take steps to prohibit insider trading in securities. So insider trading is basically the trading of the securities of any company by the insiders who have access to the information which is not publicly known. It also has the powers to compel the companies to list their shares in more than one stock exchange. It has the powers of a civil court in dealing with any malpractices on stock exchanges. It has the power to access all the records of stock exchanges and check their working. It can register and regulate brokers and other middlemen. National Green Tribunal (NGT). The National Green Tribunal was established under the National Green Tribunal Act of 2010. The aim of establishing NGT was to reduce the burden of litigation in the courts and for the speedy disposal of cases related to environmental protection. The principal seat of the tribunal is at New Delhi. Composition. NGT consists of a chairperson, judicial and expert members. So as we can see, in most of the bodies, expert members have also been included. This is for securing the field or subject expertise. The chairperson should be a retired Chief Justice of India. Other judicial members are retired judges of High Court. The expert members should have an experience of minimum 15 years in the field of subjects related to environment conservation. The chairperson and members hold the office for a term of 5 years. Powers. To resolve various cases concerning the following laws: Water Prevention and Control of Pollution Act of 1974, Water Prevention and Control of Pollution Cess Act of 1977, Air Prevention and Control of Pollution Act of 1981, the Forest Conservation Act of 1980, the Environment Protection Act of 1986, the Public Liability Insurance Act of 1991, and the Biological Diversity Act of 2002. To provide relief and compensation to the victims of environmental damage. Taking steps for the strict implementation of Environment Impact Assessment, that is EIA. NGT is not bound by the procedure laid down in the Code of Civil Procedure of 1908 and is guided by the principles of natural justice. Basically, the principles of natural justice in simple terms means that the law should be fair and the decision-making process should be impartial. To impose penalty for non-compliance of its orders. The appeals against the decisions of NGT are dealt by the Supreme Court. Electricity Ombudsman. It strives to resolve the grievances or disputes of the electricity consumers. He acts as the appellate authority and takes up the grievances which does not get satisfied at the lower level. The Ombudsman passes an order which is binding on both the parties. He also has the power to impose penalties for non-compliance of the orders passed. So that's all for this video. Thank you for your patience. See you all with another video.